at the latest.
Yes.
I think we all are in support of pulling the late night if we get that information. So
I am very sensitive to that same thing. So with you on that, that's part of what motivates this. Yeah.
I have the list of stipulations. Should I approach?
Please do.
Okay. As long as they're on here, they're stipulated to. There are a couple notations. Don't worry about that.
Okay. Red ink and black ink are the same?
Yes, there's everything is the same. If it's on there, it's stipulated to. I just added it with red.
No, that's fine. Just as long as there wasn't a super stipulation meant by red or something like that.
I'm so sorry, Your Honor.
You want?
I just want to take a really close
Yeah,
look
of
because I
course.
haven't
Yeah.
seen it.
It's your hand.
Yes, but it has your additions on it.
Yeah.
I'm not
It's only
accusing
Fisher.
anything. It's
No,
just-
no, again,
Great.
similar to what I was saying about the stipulations. We'll all do our jobs, but
due diligence
respect
for-
where it is.
for- That's fine. Thank you. Thank you, Mr. Oliver.
Your Honor, may I raise one other thing while we have a minute?
Yes, you may.
We talked last week about the question of openings. There is a dispute between the parties regarding the openings.
Okay.
I don't think it'll take long to resolve, but I think it would be helpful to get Your Honor's guidance on it, given that openings are on Monday.
Right.
The dispute is this, that the state has proposed that the parties not exchange their opening demonstratives, unlike the rule that Your Honor has already ruled that we should exchange demonstratives 48 hours in advance. We do not agree with that. We think, frankly, Your Honor has already resolved this question and has ruled that we should exchange demonstratives 48 hours in advance. And I think that doing this for for the opening is the most important of all the sharing of the demonstratives. I also worry that the state's proposal is going to be very inefficient because we anticipate, notwithstanding what was said yesterday, that there are going to be a lot of pictures and suicide stuff and child porn and stuff like that. And I would like to resolve those issues before we're standing up in front of the jury and waving all that around. I also anticipate that we're going to see some of these pseudo expert reports that we've been fighting about in the motions in limine that we think are obviously inappropriate under Rule 701, as well as hearsay. And Your Honor, in ruling on the motions in limine, said that the time to resolve those issues is in the specific once they're there. And so what I worry about is if we're just doing it flying in front of the jury, that's going to force me to object during the opening. We're going to have to come up, approach the bench. The noise machine is going to overheat. We're going to start a fire. And I really don't think we ought to do that. Now, I expect that my colleague is going to say, oh, I'll just put it all out there. And, you know, if I can't get that stuff into evidence, then, you know, that's on me. But the problem with the nature of the evidence we're talking about here, Your Honor, is once some of these things are out there in front of the jury, even if they're ultimately not admitted, they're going to be seared into the jurors' minds, and the prejudice will already have been done. And as Mr. Parkinson likes to say, the horse will have left the barn. So we respectfully suggest we stick with the court's ruling, exchange 48 hours in advance. That morning before openings, we can come have an argument about it, and Your Honor will rule.
All right. May, Your Honor? Yep. Thank you. I don't believe the court did rule on this. The court ruled on evidence. And this is not evidence, as the court has said. This is a roadmap. The counsel will, I believe, agree with me that in the other litigation pending right now, there's also no disclosure of openings between parties. That's because openings are not evidence. The purpose of the 48-hour disclosure is to make sure that competent evidence within the four corners of the room stays in the room and it's appropriate for the jurors to hear as evidence. This court instructs the jury that what you're about to hear is not evidence. It is counsel's roadmap about what you're supposed to hear in this case, and you'll hear from both counsel, and then evidence will begin. Now, what's incredibly unfair about this characterization of it being important, more important than anything else, is that this is yet another attempt to pre-litigate the case, to learn what we're going to do in advance. And how it absolutely prejudices the plaintiff is that the entire opening now becomes us presenting our roadmap with all of the cautions that we put into it, because we have to actually produce that at trial. If we leave something out, we can't actually justify it at the end. That is our our vulnerability. That's the standard we hold ourselves to. In terms of this repeated idea that we're going to show explicit sexual exploitation and child rape in video, first of all, I take tremendous offense to the suggestion that that's what we're doing, that we don't know how to present that kind of evidence in the appropriate way, given the severity of the allegations, but also the candor and the decorum of the court. It's a repeated accusation that's absolutely unjustified and inappropriate. But we have to govern ourselves like we do in every case. And we don't, they know that this is not a standard practice to disclose opening slides in cases like this. So, but we'll end up having an opening where they now have 48 hours to spend their entire verbal part of their 2 hours refuting our case. So ours becomes a roadmap, their opening becomes argument, and that's patently unfair to us.
Sure. So let me ask, because there's two, as I view it, sort of competing issues here for opening. Welcome. The people are happier to see you than they are anybody else, I promise.
Sure they are.
All right, so those two competing things are, one, trying to make sure that everything is conducted in a fair fashion. The other one is trying to make sure that it's reasonably smooth and that Mr. Huff's prediction of white noise drowning out the opening is not accurate. So what I would, I guess, like to know, Mr. Milior, is what is your proposed plan with respect to openings to make sure that we're not dealing with objections constantly? And
Your Honor, and I appreciate that. To solve the problem, they seem to keep repeating this refrain that we're going to show explicit graphic images. I would be willing 24 hours in advance to share with them how we intend to show those images appropriately and discreetly. As to how we roadmap the case and the strategy, that should be left to us to do and use our own professional guidance as professionals, as members of this court. There may be a question, I think we've raised two other issues I would propose, that we have a discussion about the advisory, Surgeon General advisory, because you told us that we need to leave the court, and the congressional statements. And we can share with them those handful of slides so that we can address to the court that issue. Otherwise, we've had 2 weeks of solid motions in limine. We know exactly where the court expects us to operate in our lane. We're professionals and we intend to stay well within that lane, Your Honor.
Your Honor, if I may be heard, my understanding of this court's practice is that you exchange your demonstratives in advance of the opening. Ms. Stambaugh tells me that in the tobacco trials she's done in front of Your Honor requires that to avoid this very thing, the hide the ball and me having to jump up in front of the jury. Our concern is not limited to the explicit images. As I mentioned, we think that there are various pseudo-expert reports they're going to try to get in. We just ought to exchange we're going to show them our demonstratives. It's a two-way street. They will have a roadmap into what we're going to say. Every trial I've ever done, there's been an exchange of the openings so that we can have this argument outside the scope of the jury so that I don't have to jump up in front of the jury and object in order to preserve my objections, which I'm going to have to do, and I don't want to do that. So I think the fair thing to do is follow what is already in the pre-trial order. Your Honor ordered all demonstratives exchanged 48 hours in advance. We can do that, and we can have an orderly process. That's what we would suggest.
all right. And Mr. Miller,
The only thing I'd say, Your Honor, we have the same issue. That is, we run the same risk of having to get up. And the truth is that that's what governs proper conduct, is knowing that there's a balance between protecting the record and not being obstreperous. And so this is not an issue that professionals should have to pre-litigate 48 hours in advance.
all right. Well, and I guess here's where I'm stuck, because it's also not something that we should be having to litigate in the midst of openings. So that's where I'm trying to figure out what you propose as a, again, and by the way, I will say, in terms of how the court handles this, I absolutely will say that this has been a case-by-case decision for me. So for instance, in the tobacco cases, my distinct impression has been, for instance, that everyone has seen 80 to 90% of the case before in other presentations, and everyone knows what their issues are and the like. And so it's not that hard to have that sharing in advance. There are other trials, and this may be one, where the strategies and development and the like are, I guess, the fairness piece requires less disclosure or less advanced disclosure than the tobacco cases. So I just want to say, you would have me on, I'm not exactly, standardized or uniform when it comes to the decision about how far in advance. But Mr. Migliore, I've never conducted a trial with 2-hour openings where no one has disclosed anything related to what they'll be presenting before they get up there and start talking. So
Absolutely, Your Honor. So we've proposed the sexually explicit material. That's a legitimate concern. We'll be happy to share. We intend to use 48 hours in advance. Quite honestly, I only think 24 is necessary, but I'll let the court decide between the two. Obviously, let the court out. I will be honored to accept whatever of the two the court says. The other, Your Honor, I said that it's appropriate, I think, since leave of court's necessary, to share the Surgeon General advisory only, not the opinion letter.
Right.
And the
and I think, and I apologize, maybe I was ambiguous because I think we had a hearing where I ruled leave of court.
correct.
And you said, I want leave of court, and I
Correct.
thought I had said, yeah, you've got leave of court. So
Okay.
you run the risk
Okay.
of issues later on, but yes.
Okay, so that's clear. So we can use it. I'll still show them the passages. Happy to do that if that's one of the issues. And then, Your Honor, there's this repeated refrain that somehow we're going to operate outside of the court's rulings. I don't know if you use the word sham or some kind of expert reports. We've got your guidance on what's an expert and what's not. And we're not going to show any expert reports on the screen. We're going to talk about what each witness brings to the case and the evidence that they will hear, or we hope that they will hear in the case. So I don't think producing our witnesses' storyboards is an issue, or that the risk of us somehow running afoul of the court's ruling. But if there's a specific person they want to know something about what we're going to say on a demonstrative, I'm happy to meet and confer on that. But I don't understand this idea that somehow they have to police us to make sure we abide by the court's ruling.
Your Honor, may I respond to
sure,
that? This is leading towards a train wreck. Your Honor, we filed multiple motions in limine on multiple issues. I haven't raised every single one of them here today, but there's the Molly Russell video. There are these, I do call them pseudo expert reports. There are these reports that these people who are professional haters of Meta have created that they are going to talk about with their witnesses, and they're going to put them up there and say, you know, this guy did this report and look at what he found. He found all this stuff. We moved in limine on that stuff. Your Honor said, I will decide that when it's presented in the specific. When they do that, I'm going to have to jump up in front of the jury and say, this is an objection and we're going to have to fight it out. I respectfully suggest 48 hours in advance, we can then have an argument the morning of, and Your Honor can rule on it so that I don't have to be constantly jumping up. I just think it's the only fair way. My concern is not just about the images. It is much, much broader than that. It's all of the motions in limine we filed.
So if I may, very briefly.
Yep.
So what I'm hearing is that this 48-hour rule is now going to cause us to relitigate all of the in limines. There are no in limines that have not been ruled on and that we haven't had your absolute clear guidance for. So now what I'm hearing is they want to retest every in limine that we took 3 weeks. So the weekend before the opening, we have to now relitigate all of your in limines.
So here's what I think we can do. Because again, I will say, from this and many other trials, I understand that when it comes to openings, there is a certain amount of strategy and the like that doesn't necessarily apply to introduction of evidence throughout the trial and the like. I do also recognize that there are a number of rulings where the answer was leave of court in advance. So, with respect to, evidence that's going to be presented in opening where the ruling was leave of court, just like the Surgeon General's, report, share that 48 hours in advance to make sure, and by that I mean what, I guess really Saturday, to make sure that Monday morning we can come in and sort through any of those evidentiary objections, or maybe I should just skip to the point and say all of the evidentiary objections, and make openings as smooth as possible. With respect to, the witness roadmaps or the like, to the extent that that's a demonstrative, I don't rule that has to be by either side, just, shared in advance if it's a summary of what the testimony is going to be. But the evidence it's based on, that's what needs to be shared, at least 40 hours, where there's any leave of court issue. If it's allowed or it's denied, then the ruling is cleared. If it's been, disallowed, which there hasn't been a ton of that, so I'm expecting it's mostly going to be leave of court rulings, I want to make sure that we can get through those objections before openings start on Monday. And I don't want them to start at 10:30.
May I ask one point of clarification, Your
Yes.
Honor? Some of the motions in limine rulings were that Your Honor would rule on, say, a 701 objection, at the time. Does Your Honor's order include that kind of thing where they may be putting in a 701 report that we moved in limine on, and Your Honor said that you would address that at the time?
If I said that it's going to be a leave of court ruling, or ruling of that nature, I think sharing it in advance makes sense. And again, I am not thinking necessarily that what this means is that I will be making rulings in advance of opening. I think that'd be contrary to a lot of those rulings. But I want to make sure that at least there has been a ruling on which of those, if there are objections that are sustained, and we deal with that before openings that are not just constantly interrupting each other throughout. And that's also true. This goes both ways.
So we will look for leave of court within the hearing and the ruling and tie it to anything that we intend to use. There are rulings, of course, Your Honor, we say, I deny this, but of course it's without prejudice. Wait to see what the evidence happens. That's not leave of court as we understand it, right? It's denied. And
So so I guess what I'm trying to say, so where I said leave of court, then, before that is presented, we're going to need to have a discussion of that after you all conferred and a ruling of the court about openings. Where I denied it, then the risk falls on the party. I think that is
correct.
Mentioning it in openings. And if I later on ruled that's excluded and that jury is left, I understand you're worried about ringing the bell, but the flip side of that is there's plenty of prejudice from jurors that have been told,
right,
we're going to see this thing, and wait a minute, why did they never present it? So I think that washes out a bit.
We appreciate that.
So just to be clear, Your Honor, so the court doesn't get mad at me in the event.
Yep.
There are going to be several things that I expect they will present where we have very strong objections and real unringing the bell problems. And I'm going to have to stand up and object in order to, preserve my objection. And an example of this are these, expert reports that I expect they're going to try to show to the jury in the opening, and I'm going to be forced to object to that.
And here's the thing, a decision that both sides will need to make in advance is if the prospect of that interruption and whatever transpires in front of the jury, if avoiding that is a strong enough incentive, share, confer, and bring it to me in advance. And if what either side needs to do is stand up and object, then yes, you will see me scowl at everyone, but I understand that's your jobs and we'll deal with that at the time.
Thank you, Your Honor. And we can govern ourselves that way perfectly. The question I have is, you said that we were granted leave of court on the advisory,
Yes.
meaning we can at this
I,
point. You said
I
have a res-
apologize. I thought that's what I had said in an earlier
Okay.
hearing, was that you would ask for, I rule leave of court, and then you said, what about this? And I said, you just asked for leave of court, then I
You
thought it
have
was
it.
granted, yes.
And I want to clarify, just so says we go into the weekend, we have an understanding also on the congressional testimony. I asked for that at the moment, and you ended it by saying, I'm starting to see this as something different than lobbying, but I don't know that we heard you say, yes, you have leave of court. If we need to wait over the weekend, we can do that, but I thought that's where the court was.
Okay, I will just say on that, maybe the most helpful thing will be if you all can direct me back to what motion that was, and I'll look through it
Fair
again to
enough.
make sure I'm prepared for that.
We'll do
Because
that,
I'm
Your-
sitting up here focusing on jury issues. I will confess,
I was too. I didn't even have my notes for this. Thank you.
Sorry, last
Yes, sir.
question, Your Honor. Is it clear that the images and videos, at least, we're going to get to see those in advance?
I've offered that, and I'd
Yes.
stand by that, Your Honor.
yes. And by the way, I mean, I say across the board, so I have not seen all of these, at least in a size that is large enough for me to really be able to discern. I mean, I am operating with the understanding that no one is out. I mean, I know that there are unpleasant images, but I'm assuming there's some pixelation or there's something on these things that, you know, make it remotely sensitive in terms of how it's presented to the jurors.
If it wasn't clear from yesterday that it would be very detrimental to the state to try to shock people with highly inappropriate material, it's absolutely clear today. And so we're happy to share that in 48 hours of the opening slides we intend, not all of them for the case, because we're still working on that. But we'll be happy to share it. And if the court would like us to disclose to the court in 48 hours, we'd be happy to share what we disclose to them.
All right. What I will need is for you all to have shared and conferred
Okay.
on as much of what I've just talked about as possible. So that, I mean, again, what I'm expecting is we show up on Monday and there will be perhaps from both sides, some objections to what is going to be shown in each other's openings. And I do not want to start this jury trial with jurors sitting in the deliberation room for an hour and a half waiting for us to get through it. So the more that you all have been able to confer, and again, if there's some objections in the midst, then I'm sure those will be the last ones I hear for the next 7 weeks. But sarcasm aside, I understand you guys are going to do your jobs, and that's fine. But I do want to see that you confer on what you can and bring that to me first thing on Monday morning to see if we can get through this in a reasonable time frame.
We will, Your Honor. Thank you.
Thank you, Your Honor. Alex Parkinson.
Yes, sir.
Platforms. I just want to make one point of clarification. We've been talking about the opening demonstratives,
Yep.
not other demonstratives. As your
Correct.
Honor knows, the PTO says 48 hours for demonstratives.
No, and that's what I was also stating about. I understand that openings are for both sides a bit different, and so
I'm reacting to a statement. The purpose of the 40-hour disclosure is to make sure that common evidence within the four corners of the room stays in the room and it's appropriate for the jurors to hear as evidence. Just want to make clear that the PTO has a 48-hour disclosure for evidence and another 48-hour disclosure for demonstratives. It would apply to a witness that is appearing, for example, on Monday. Just want to make that clarification. for the record.
This is the problem with real time. I was just describing that the disclosure rule has to do with protecting the integrity of what goes before the jury. Thank you.
I understood where you're going with it. And that's again, part of the basis for that. But yes, we're going to have an orderly trial. You all will be disclosing to each other probably further in advance than you want. But it is my distinct impression that that is what's going to help keep this train on the tracks and not have 7 weeks of unproductive interruptions. So,
Thank you, Your Honor.
all right, thank you. And let's see, I'm assuming that while we've been having this discussion, amazingly productive people are working on supplemental questionnaires. And shatter my illusion if that's wrong. All right, so let's see, are we about ready to head down? Cool. All right, well then, let's do it. Thank you. Thank you. See you down there.
Alex?
You should have 8.